A review and simple rules to remember when working with LLCs, corporations, trusts, estates, and.
That's quite a mouthful.
Nonetheless, Tiffany with Kelly and Oregon. There you go, girl.
Make sure, okay. So today I'm going to talk about proper execution of contracts, and I'm going to give kind of a few little scenarios so you understand why we're talking about this. When I was at GAR Train the Trainer back in December, where we all go that teach GAR forms to learn the new GAR forms, one of the big topics that came up was execution contracts, and it led to like a big discussion that didn't really lead anywhere other than all of us kind of agreeing that 90% of the time you get away with not executing them properly, and that 10% of the time can be really bad. And there's even new language on the forms this year that are like reminds you if you're signing in your corporate capacity, like to sign as member, sign as manager, sign as president, secretary, whatever you are. But just so you know why we're talking about this, say I have an LLC with my brother. It's Thornberry McWhorter LLC. And we own some property and I list it with you and I sign a contract with you and I just sign Tiffany McWhorter and that's it. And then 2 weeks later, another buyer comes along and offers $50,000 more and I want to get out of that contract. So I terminate and the buyer says, no, we're going to sue you for specific performance. We want this property. That LLC can say, Tiffany McWhorter signed this contract. The LLC didn't sign it. Does it say anything else about the LLC owning it? Did she sign as her capacity as a member manager? And so that you may have some liability. I mean, I may have some liability personally for signing a contract on a property that I didn't own, but that property is completely free of that contract because it was not signed properly. Nothing bound that property to the contract because me signing my name individually without any reference to the LLC, without any reference to why I'm signing it, is just a completely unenforceable contract. So my rule or anytime you're working with property that's not owned by an individual, if you are standing with somebody who is not the person who is untitled to that property, that's what we're talking about here. And so some of the common parties that you guys will see are going to be limited liability companies. That's probably the most common. Corporations, so anything that ends in an INC, estates, trust, and powers of attorney. All of these, and I didn't put partnership up there or custodianship, but all of it kind of falls under the same, the little rule of three that I'm about to go over in just a couple minutes. So 3 components. Like, it doesn't matter if you're working with any of those, and I don't expect everybody to memorize what we're going to go through on the next slides. But anytime you're working with someone who's not the actual physical individual owner, there's going to be 3 components that you're looking for in your signature block. And when I say signature block, the people don't have to sign out everything that we're going to type, and I'm going to give you some sample signature blocks. But it does all need to be on there in your printed name. So like the printed owner, the printed seller, you know, whoever, whatever you're printing in there. And so you want to have who's party to the contract. Is it a buyer or seller? Is it an owner? Whoever the party to the contract is. So whoever you're trying to bind, that's your number one person that you want to identify. So in my example, it would have been Thornberry McWhorter LLC. And then you identify who's signing, and that would be Tiffany McWhorter, and then in what capacity as managing member. So there's always going to be 3 components, and we're going to go through all of them. But if you can remember that, then you'll be golden. Because a lot of times you're not going to remember if an estate with a will has an administrator or an executor, you know. But just remember you're looking for the party, who's signing, and what's their capacity. If you've got all 3 of those, then you'll be good.
Party to the K.
Sorry, that's law school abbreviation contract.
Okay. I just wanted to make sure. I thought maybe it was like a K1 or.
No, and I don't even know why we use K and not C. We use K. Sorry, that is, but it really is K. That's the abbreviation for contract. I didn't even realize I did that, y'all. And I've been out of law school for like 18 years. That's funny. Some habits die hard.
So I just want to make sure that I'm following this along. So if my builder, who is Stevens Communities LLC, owns the property, it's signed Stevens Communities LLC, Chad Golden, I forgot his last name for a second, as member partner.
Then you remember whatever their capacity is. And whoever you're working with should know what their capacity is, like they should know their position.
So all that needs to be on there?
Everything needs to be typed up.
Okay.
And it's not up to you guys, like y'all aren't charged with reviewing the corporate documents, making sure that whoever's telling you that they're the managing member, I don't expect y'all to get operating agreements and do all the things that we do on title. That's our job. So once we get a contract that says it's an LLC, then we ask for all of that, because that, as in the title clearance process, we make sure that the people actually have the authority to sign. But don't feel like you need to be reviewing trusts or estates or anything like that. You just want to identify who's signing.
But if it's not on the original contract, then by amendment, we have to put that in there, right? Okay.
And here's your example. So we are starting with limited liability company. So you want the name of the company, obviously, whoever owns the property, whoever the party to the contract is, the name of the signer, and then LLCs are supposed to have member managers. I see it done improperly all the time, where you'll have an operating agreement that names the president of an LLC, which doesn't really make any sense. But whatever their managing capacity is, whatever their title is what you're going to want to use there. So I used O'Kelly and Sorahan as an example. And I did this because you want to make sure you include the full name. So our full name of the LLC is really long. O'Kelly and Sorahan, Attorneys at Law, LLC. And then the legal name that's on there, Joe F. O'Kelly Jr. as managing member. And so that, it is a lot. That's a mouthful. That's a lot to type in there. But that, in order to bind a contract that O'Kelly and Sorahan on a property O'Kelly and Sorahan own, this is what everything that you would want to have typed out. And then Joe could just sign his name. So you don't have to sign out all of that stuff. If you don't know, do you guys use Secretary of State's website ever? It's really easy. If you just Google SOS Georgia. You can pull up, the formation documents for the LLCs or corporations. A lot of companies file their operating agreements, but a lot of them don't. But if you look at the initial filing, that's where I can normally see who the managers are. So the yearly filing doesn't have that, but the one they initially filed does. And then if it's changed at all, they normally, will record a modification or something. Okay, so corporations, anything that ends in INC, same thing, name of the corporation, the name of the signer. And then your signers for corporations should be either president or secretary. Sometimes you see secretary treasurer, or sometimes we'll see like CEO, CFO, things like that. But most of the time with corporations that are working in land, you're going to see president. And so signature block, I just did Facebook Inc. because it was the first corporation I could think of. By Mark Zuckerberg, it's CEO. So same things, just 3 components. Whoever the party to the contract is what you want to start with, who's signing, and then in what capacity. All right, states. This is, with the states, if you die and you do not have a will, your personal representative is administrator. If you die and you do have a will, your personal representative is a executive. You guys don't have to remember that. But what you're looking for is who's signing and how, what their capacity is. What the court gives you in the probate court is called letters testamentary. So if you've been sworn in as an executor or administrator, that's what they're going to have. And it names them. So it'll say Tiffany McWhorter is now the executor of this estate. So same thing with the states, you want to sign who's the deceased owner, who's the party to the contract. So I use my father as an example here, Philip Thornberry. The name of the signer would be me. And then he passed away with the will that we probated, and so I was executor. So same 3 things. You're just, you see the pattern here? It's the same 3 things. But that's really important. And then one thing I wanted to talk about on this slide is if you're working with an estate that hasn't gone through the probate process completely yet, so there hasn't been somebody named or sworn in as an administrator or executor, you really need to use the GAR special stip that I should have written down the number for, but it's, I think it's in the 600s. But it's about that the sale is contingent on court approval or a court order. And that court order that you're speaking of here is going to be the letters testamentary. Because if you have me sign before the estate's been probated, you want that contract to be contingent on me actually being appointed as the executor or the administrator. A lot of listings will go live before the whole probate process is done. And so people who are signing, in theory, have the authority, but it hasn't been granted yet by the court. So they're like, oh, but I have this will. That's great, but you have to go get the permission, you have to go through the full process of getting that award. Does that make sense? All right, trust is the only one that's a little bit different. Still 3 components, but trusts are not legal entities. So when you think about it, all these other things, you're thinking of an entity that's recognized as an owner of a property. A trust is set up so that one person can hold property or money or whatever it is in trust for someone else. But the actual trust cannot own property. So one individual is holding it in trust for somebody else. So you start with the name of the trustee, and because that's who owns the property. The trust doesn't own the property. And then what their position is, that's the second component as trustee, and then the name of the trust. If y'all mess this up, it's really no big deal. If they're in a different order, if you go with the same order that we've used all the time, as long as all three components are there, you're good. But this is how you will see it. I have an 11-year-old daughter, so Taylor Swift came to mind. So Taylor Swift would be the owner of the property as trustee of the Swift Family Trust, and you always include the date. If y'all don't get that 100% right, that's okay, but that would be the perfect signature block. You always want to include the date of the trust. And if you know that's her birthday, then you get bonus points. But, I have all the Swift information you could ever want. But does that make sense? Because a lot of times you'll see the property titled wrong. Just completely wrong. And we'll have to amend it during the title clearance process because it'll be titled in the McWhorter Family Trust and it won't identify a trustee. It won't identify the date, anything like that. And that's really a bad vesting. So that was a bad transfer when they transferred into the trust. But a lot of times people go online and print their own deeds and, do all that kind of stuff. But a trust cannot hold title to a property. It has to be in the name of the trustee in trust for somebody else. And then while we're talking about estates and trust, we have to have all that documentation in the title clearance process. So as you're talking to people, you may want to tell them, go ahead and get a copy of your trust, get a copy of the will, get a copy of your estate documentation. If the property is in the same county that it was filed in, then our title clerks will pull them. But if it's not, which is really common, so your probate was in Gwinnett County, but you own property in Hall, a title search in Hall County is not going to reveal the Gwinnett County probate because they're not going to go search every county in Georgia. But we have to have the full will, we have to have the full trust, we have to make sure that whoever's signing, that's all our job as part of the title clearance process. But the earlier people start looking for that, estates tend to be pretty easy to find, but trust people, sometimes it's like pulling teeth in order to get them to give us a copy of their trust, and they're super secretive about it. They don't want us to see everything. But we have to. So we get past that, but the earlier they hear that, the better. All right, and power of attorney. This is probably, besides LLCs, the most common thing that you guys work with. But in the wake of digital contracts and digital listing agreements and all that kind of stuff, my preference, and I think Keller Williams' preference, you hear it from the broker boys also, is to have the actual party to the contract sign your listing agreements and your contracts. You want to use power of attorney only if you absolutely have to on your contracts, because it doesn't matter if they're in Dubai. You can email them a contract, they can DocuSign or electronically sign that. It's always better to have the party sign if they can electronically. But if they can't, you use your power of attorney. And a power of attorney allows someone to act in your stead. So that's like the legal definition of it. I am granting you the permission to act in my stead, which means you can do whatever I would do if I was there. A power of attorney is not supposed to give any negotiation power. It's not supposed to give any decision-making power. It's supposed to be, I direct you to be the person that is there to do what I want you to do in my absence. And so a big key part of that is if the person who is assigning the power of attorney dies, then the power of attorney dies. People try and use powers of attorney all the time for deceased people. And it's kind of morbid, but if the person was there and dead, they couldn't sign. So acting in their stead, that somebody else couldn't sign either. So can't use power of attorney after death. And a lot of people have like general power of attorney or durable power of attorney, financial power of attorney drawn up during their estate planning process and don't really realize that they're giving as much power as they are to whoever they assign as their power of attorney. So estate attorneys will say, oh, as part of this, while we're doing your will or your trust, do you want to do a financial power of attorney? And they're saying, yeah, that's great. And so say my dad signed one and he's giving me power. And if you include all the powers that are normally included in those, it's the power of real estate transactions. And so title companies don't love that. They want a specific power of attorney for real estate transactions because power of attorney fraud is like one of the top 3 claims, I think. So if at all possible, we have to have a specific power of attorney that says, I, Tiffany McWhorter, grant you, Julie Cunningham, permission to sign for this property specifically with this buyer, this seller. And I know if you've got loans, they have to be specific. We get them approved with the lender's underwriters first, just to make sure that it's got all the language, like the lenders even want the loan, like the lender's name, you know, all that kind of stuff in there. So we have to have a specific power of attorney is the rule. The only time that rule is not enforced is if the person is incapacitated. So they no longer can sign a new power of attorney. We have to get a doctor's note from a treating physician that says either they no longer have the mental capacity or the physical capacity, whatever it is, to sign. And so then that triggers the durable or the financial power of attorney to be able to be used. So same thing, the first component is the name of the party to the contract. So big Braves fan, I used Ozzy Albies. And so that's the owner of your property. The name of the signer by Andrea Albies, that's his wife. And then capacity as power of attorney, his attorney in fact. If you mess up the word, I don't know why we say power of attorney, but we sign attorney in fact. You can sign as power of attorney. It's not, there's no legal consequence there. But the way you'll see it on our documents is his attorney in fact. Anything else I wanted to say on powers? At the tip of my tongue. Oh, we always want to look for expiration dates. So a lot of times, like people will have powers of attorney that are really old from estate planning. Those are normally towards the end of it. We always look for that. But title companies require that they have one. So they don't like the unlimited ones where it just says forever. So if we're preparing one for like a listing that you have and somebody's going out of town, then we always ask like, how long do you want this in effect? Because they, you know, they don't want it to go forever.
Do some of them not have them? Because I feel like okay.
Some of them don't. And
And then it does go on forever?
it does.
Okay, thank you.
Well, until they die.
Okay, thanks.
But when you are, another thing with power of attorney, if you're getting us to prepare a power of attorney for you for a transaction, our general power or the specific power of attorney that we generally use does not contain contract language in it. So it's assuming that the contract has been signed and you're giving authority to somebody to come sign to close out that sale. So it'll say, you know, have this property address between this buyer and this seller. And that's what they're looking for at the title side. If you know that your seller's going out of town and you need a power of attorney for them somebody to be able to sign contracts for them, make sure that you are telling whoever's preparing the power of attorney that, because we have a power of attorney that does have contract language in it where they're able to sign contracts, listing agreements, stuff like that. But that's not the one that we use in general. In general, we assume that you've got a contract and they're just signing for them.
Correct me if I'm wrong, but generally speaking, you would rather provide the power of attorney.
Absolutely.
Okay.
Yeah.
I've always done that with you guys, so,
Mhm.
because that way I know that it's right and I don't have to get anything else signed on.
And, you know, there is a fee for that, but if, not that I want to advertise, we'll waive it sometimes, but if people have a power of attorney and they come to me and they say like, I already have one, but you're requiring this different one, and I paid $250 for this one, why can't I use it? Then I normally will say like, just use mine anyway, we'll waive the fee on that, but, they have to be signed with a witness and a notary, same thing as deeds. And I don't know, notaries have gotten a little tighter on what they'll sign. Like it used to be, you could find a bank notary to sign anything, but then they stopped signing deeds. Now some of them have stopped signing powers of attorney, which is actually probably pretty smart on the notary side, on the bank's like liability side. But I had one more thought on what you said, Julie. What did you ask about?
I asked about the expiration date on the,
And then you asked about preparing them. Oh, on the lender side, if we are preparing one for a buyer who's going to be signing loan documents, it takes a little longer because we prepare it, then we send it to the underwriter, they get it reviewed and approved before we ever have it executed. So like with guarantee, I know they've approved our power of attorney in the meantime, so I can feel pretty confident sending that one out. But if it's a lender that we haven't worked with yet, just know it takes a little bit longer to get that approved. That the underwriter wants to make sure.
Yeah, don't wait for
Don't
like the
send
week
it
of
the
data.
Yeah.
Wait the day before close, like, here's the power of attorney.
Yeah.
Why didn't you show me this? Like, can you see this?
And I mean, on our info
Thanks,
sheets.
Tiffany, we appreciate you.
On our info sheets, it says, will you be present at closing? So that we try to get that information up front, but sometimes people don't know, like that something comes up last minute and they have to do a power of attorney. Our documents are all prepared differently for all of these transactions. So the earlier we know, the better. I mean, I can't tell you how many times I've had somebody show up at closing with the power of attorney in hand and say like, oh, I'm here for my dad or my mom. And they never even told us that they were coming. So that's like a, full stop. We have to get it approved. We have to, redo all the documents. So make sure that if you're working with someone who's not the actual owner, that you let us know up front. Think of anything else. Power of attorney is like the bane of my existence sometimes, but it's so necessary. So,
I'm gonna add to that, when the attorney sends out the seller or buyer information sheet, get it done. Jessica and I were just talking about this. I got a crusty old seller that's had a week and a half and we can't get the guy to sign the damn thing. We're supposed to close in a couple of days. So it's like, now the attorney's wondering about it too.
and on the seller's and the buyer side, it's kind of important. On the seller side, it's incredibly important because it's got the signature that we need to order payoffs. We have to have their socials to order payoffs. We have to have their loan numbers, and it is more of a pain for them to fill out. But if you guys are doing that kind of prep work at the listing stage and say, once we go under contract, the attorney's gonna need your loan number, your social security number, all this information. You may want to go ahead and start gathering that now. The more they hear it, the better. But some of them are just, some of them won't even give us their socials over the phone or over internet. So they want to come in and give it to us, which is fine. I can understand people have been burned by that. So but we have to have it. And we do have to report the sale to the IRS. That's why we have to. People do not like that. Yep, that's it. Do y'all have any questions about that as in execution in general and with contracts?
So, okay, I'm sorry to keep asking these questions. I want to make sure I'm straight on this. The capacity as power of attorney, you're wanting to know there, is it specific or general, or you just want to know that they are the power?
Yeah, I just want you to have it written out, like you want their capacity
Okay.
written as attorney in fact, or as power of attorney. You want all three components to have a line, so if you go back, if you look through all of those, it's like the name of the LLC, the name of the signer as in their capacity, the name of the company, the name of the signer, his capacity, the name of the deceased, the name of the signer, my capacity. Keep on the wrong way. Name of the trustee, in this case, as trustee, so that's their capacity of this trust, the name of the trust. And then same thing with power of attorney. So you always have three components. That's what you're looking for. Simple.
An actual signature line, does the LLC's the name, but it also has to be signed as LLC?
Nope. So,
Just the name and their position?
yeah, just the name and their position. Yeah, that's fine. You don't have to sign out the actual name. The only one of these signatures that we require you sign out every single word of on closing documents is power of attorney. So the power of attorney has to sign, it would be Ozzie Albies by Andrea Albies as attorney in fact. The rest of them, we just allow you to sign, like Tiffany McWhorter as trustee, or I couldn't tell you if you paid me $1 million why that is, but that's just what's accepted. Title standards in Georgia. So I didn't write them, I just enforced them. Do you have any other questions on execution? Can it be with individuals? But the big thing is you want to make, the reason why we're talking about this is to make sure that you are putting your clients in a position to have enforceable contracts. They're not worth the paper that they're written on unless they're executed properly. So you can really get a little dicey with people not executing properly.
I do a lot of probate stuff, and I had something come up a couple weeks ago that they were talking about the trust and the 5-year look back on Medicare, Medicaid, and I was trying to learn more about that. So what's your thought, what are the details on that?
So the 5-year look back in Medicare, Medicaid is if you are a person trying to get Medicare or Medicaid coverage for things like nursing home or stuff like that. And what they go to first is your own assets. So like if my mom were to try and get Medicare or Medicaid to pay for her nursing home this year, she owns a house outright, doesn't have a loan on it or anything like that. So they're gonna look at that asset as part of her assets and say, well, why do you need us to pay for it when you've got all this money?
Makes sense.
If she transferred it to me today, there's a 5-year look back where they still look at that.
That's one, okay, so if she transferred it to you today, they're gonna look back to see when she, okay. that's-
5 years.
Okay, that's what I was thinking too.
Which is why you'll hear a lot of estate attorneys, especially with people who are older, like, go ahead and transfer to your trust now, because that 5-year look back.
Because you have to have 5 year, like if they, something happens within that 5 years, okay. All right, thanks.
What do you say?
Mhm.
And I know enough about estates to be dangerous, but somebody is coming next month who knows a lot, or she's coming in March. March. March 4th, we have somebody coming from O'Kelly and Sorahan that does estates and trust and all that kind of stuff. So she will be here doing your education portion, and she is a wealth of knowledge. Her name is Amy Bogarts, and she's been with us for, I think, 2 years now.
She's amazing. She
She's
helped me a
amazing.
lot.
Yeah. So, bring all your estate questions, trust, all.
Mhm. And I want to add to that, a lot of clients think they already know how to do all this and they're gonna tell you what to do and you just, so like, I love how simple you made this, like just the three things and just educate your people as soon as you know that anything in this category becomes a topic that's gonna be impactful to your transaction. Educate them. If you need help, call Tiffany, like let her be the messenger of what they can and can't do. Because sometimes that's easier than trying to teach somebody that thinks they know it all.
Yes. And I mean, most of the time it's a simple email or text. If you ever question what you're doing, just shoot me a text, shoot me an email. Hey, am I having this executed properly? I mean, I probably answer 10 of those a week, especially with power of attorney. And a lot of, in LLCs.
I got another question.
Uh-huh.
So for power of attorney, you mentioned a financial power of attorney, which usually is real estate related.
Mhm.
If they don't have that and just a regular POA, can that have exclusions in it? That they can do everything, but like it excludes any real estate transactions?
So there's like a statutory form. It's like a durable power of attorney that is recognized statewide. And there's a whole list of powers that are in there. And like you either initial, I'm giving you all these powers, or you initial were the ones that you're excluding.
Okay,
And so like if you were to Google a general power of attorney in Georgia, that's what would pop up. And so we look at that list to see if they initial, we're giving you everything or just.
What it excludes, okay.
Mhm. And it's the same thing with medical power of attorney. We used to have you'd have a living will and a medical power of attorney. Now it's called a healthcare, advanced directive of healthcare.
Mhm.
But they normally do that with estate planning also. And it's a statutory form, where you go through and you initial, do I want to be cremated or buried? Do I want to, like the 3 different types of life-saving measures, like none, food and water, stuff like that. And those are all statutory forms that, I mean, you can literally just Google it in the state of Georgia. And it's the ones that the hospital gives you if you're having surgery and you don't have a power of attorney on file with them, anything like that. But they're really good. Those have been litigated inside, outside, upwards, downwards, all the ways. So I give them to people sometimes. They're like, thank you so much. I'm like, it's on the internet. You're welcome. Thanks, Google. Any other questions?
Has anybody had any of these that have been a challenge that you couldn't get to the closing table?
Well, I have one right now that's super strange where the father and the son are 50% owners in all of their finances. The father unfortunately has been diagnosed with severe dementia at this time. And the son received the durable power of attorney in North Carolina in 2016, but they currently live in Georgia. It's a super specific one, right? But so, for example, on like a purchase and sale or all the contracts we sign, right? He's gonna have to sign it as himself, number one, and then number two, like this.
And I'm glad you brought that up. So if he's the 50% owner and a lot of times power of attorney will have to sign twice. So you're signing for your spouse, you're signing for your dad, whoever it is, you do have to sign twice. So you sign me as individual and then him as in his capacity as power of attorney for his dad. So yeah, it seems kind of silly and like closing takes longer, but you do have to sign for both parties. That's a very good point.
Because he's signing for his ownership that he has and then on behalf of his dad. Yeah.
Something else I thought of when you were saying that,
Out of state stuff.
well, that may come back to me in a second.
You brought up a question that I was thinking about, because I've had to do this once before. I think you guys did this one, where one of the people who owned the home was not gonna be able to sign because of
Yeah.
Alzheimer's or
Yeah.
dementia. And then you guys had to have an attorney, a doctor
Yeah.
write a letter of explanation for it and all that kind of
Yeah,
stuff.
it has to be a treating
Yeah.
physician, explaining why they're incapacitated.
And y'all done that for me and there were no questions asked when
Yeah,
we got that.
We got it
And you
done.
redid the.
But I mean, when that happens, because this person is technically incapacitated, don't have the ability to sign, or maybe not even know what they're signing,
Right.
it has to be done through a doctor.
And that's like a CYA on the title insurance side. They want to know why somebody's signing that it doesn't have specific, language in their contract.
As far as the lender, we always have to get a reason. We have a power of reason, they have to write a letter stating why they came to the closing.
Yeah.
And
I'm not
it's
gonna
just
Can't just be like, I don't feel
vacation,
like it.
or I don't feel like cooking. I mean, it has to be a specific.
And we used to do them for like, when the husband or wife wanted to stay home and be there with the movers, like,
Yeah,
that
no.
doesn't get approved anymore.
Yeah.
So it's like, no, get your booty to closing. But yeah, but we used to use them for a lot of reasons.
I forgot about that, yeah. And we went with all of our dogs. So we all camped out while the movers were moving us, to closing.
The strangest animal I've ever had is a parrot, an African gray tail that talked like repeatedly.
In the closing?
Oh, wow,
No
that's
way.
funny.
Like, in its cage or?
Oh, no, it was just like on a
It was just there.
Oh, wow.
What is it? Sorry.
That is it.
Yeah. That's where my mind goes. I'm like, animals aren't turned.
Oh, wow.
All right. You guys have any other questions? Does not have to be about that. Anything else troubling you lately? If y'all think of topics that you want me to cover, I think Amy's gonna come do the state stuff. And she's gonna touch on, corporations also, like if you guys want to set up LLCs and why you would do that for your personal business. And then the next one that I want to do after that is, I've done it a bunch here, but is on GSCCCA and GIS, just how to use it. Because for me, it's like second nature. I'm on both of those websites all day, every day. But just kind of little tricks on how to, find deeds, if they're in a flood zone, stuff like that. So
Have you already got it scheduled?
I don't.
Okay, I use GSCCCA all the time,
So,
and it's still confusing.
And
It's
that's
still-
what
Does everybody in the room even know what that is? Does everybody know what that is? Okay, yeah.
It's the Georgia,
I
Georgia State Clerk of the Courts
Cooperative.
Cooperative, what's the A?
Association.
That's it, whatever. that
Yeah.
is.
It's where all the clerks in the state of Georgia have combined their deed records into one website, which is amazing.
It's amazing.
It's a really great website,
Mhm.
but even if you use it a lot, you have to kind of go hunting sometimes. So that would be a really good
That would
class.
be great.
GIS is good too. I use that a lot too.
Yeah,
but
me too.
It's still another one, you gotta. hunt
Yeah,
down.
they're really good.
I start with GIS most of the time.
Oh, do you?
Because you can go into the records and it tells you the most recent deed booking page.
Yes,
Tells me
and
which
then you
deed
can
booking-
cross-reference it, yeah.
You go through Public or you just go to GIS? Because not every county does it. When it doesn't go through Public. They want to make money. Yeah.
Yes.
What are some things that have come up since your guard meeting in December that you've seen already that kind of been like some red flags they should be looking for, or things that you've seen, they're like, oh, just because with the form change updates, some stuff that's come across?
Yeah, and you guys haven't done your 3 hour with the broker boys yet.
Is this
This
Thursday?
It's Thursday,
Good,
yeah.
good. Just know, so they've changed the compensation forms, and I've been trying my hardest to say compensation.
I know.
Compensation.
So can I ask a legal question about that? What the hell's the difference?
So the thought behind it is you're establishing your worth from the beginning, and that this is my compensation. I should be paid this compensation for this service, not a commission that's based on
On your sale.
other things.
Yes.
You know what I mean? That's like not nailed down.
Okay.
It's also perception.
True.
I think that's it more than anything. It seems like it's a perception.
It is a
It's
perception
like-
thing. It's like why we're trying to get away from the word scripts and we use dialogues now.
Oh,
I thought that was-
Fancy.
Master suite, primary, you know, all
I
those
know.
things.
Oh, yeah.
But with that, the form has changed completely, which it's actually better. I like it a lot.
I think so too.
But just know that we still have to have instructions to closing attorney, with that. So we were kind of fighting that last year with a lot of people, like, they didn't want to give us, they're like, we gave you the broker compensation form and didn't want to give us the instructions of closing attorney. We still have to have them. That directs us how to pay things. With that special stip that, terminates the contract upon amendment to address concerns that's not accepted. They've changed that special stip a little bit to where it expires now at 11:58 versus midnight.
Oh, wow.
Because I guess they were saying like, if that special stip was written to where it would expire after due diligence expired. And so there's like a little 2-minute window, but with that, just know we still need a TNR. Because even if it automatically terminates with that stip, we still have to have the disbursement of earnest money portion, so just know that. What else am I seeing? The CAD really hasn't changed much, so that's good. Just make sure they're filled out.
Did you say CAD? Can you?
Community association disclosure.
I was gonna say.
If you are working with listings, make sure, one, you don't fill those out for people, and two, they fill them out properly. Because there's a lot of money at stake there. I mean, I've had to charge my neighbor like 2 doors down an initiation fee because when we bought our houses in our neighborhood, we didn't have an initiation fee. And so they just filled it out with the knowledge that they had. And now there's an initiation fee in my neighborhood that's a percentage of the sales price.
Oh my God.
Interesting.
The seller had to pay that because they didn't close it. So make sure that you're telling your listings, get this information. I don't care if you just paid it last year, find out, especially right now, because this is the time of year when they're going up. Get that information, make sure your community association disclosure is correct, because if not, your seller's on the hook to pay what they don't disclose.
Is that a management company thing or is that the
The HOA.
Oh. What's your advice on seller's disclosure statements?
Give them to them and let them fill it
That's
out.
what I said. But here's the thing is, this is something, I'm gonna just say this because it's a pain in the neck. When they don't fill it out completely, especially the check boxes about what stays in there, either put it in the contract or get them to fill it out correctly, because they leave off switch plate covers and cable jacks and all. I mean, they're obviously, I've never seen anybody go and actually take switch plate covers off, but I have had somebody take a garage door opener. So make sure you look at those things and get them to fill them out, because
Doorbells seem to be a big thing.
Doorbells, yeah, that's
Taking their
another-
ratings, cameras.
Somebody not too long ago do it backwards. Like they marked everything
that was saying, or that was.
that they were,
Going?
that was going.
Oh,
Oh,
And I'm so glad that I reviewed it. And I'm like, so you're like that, I said, you're leaving your big green egg? And I was going through these things. He says, no, I'm taking all those things. Like, oh, you did it backwards.
You're like, oh, no.
Oh, no.
You got to get away from RDR. Everyone's gonna ask what RDR is, and I'm glad I say it, because everybody needs to hear it.
Don't read.
Realtors don't read.
Oh,
Oh, I was like, I don't know.
So realtors.
ATR.
What if we don't know how to read?
Then you should not be a realtor.
Oh, man.
Right.
Yeah.
One other thing that I know they'll talk about on
Like, reel it in.
Thursday is with the unilateral extension. Now it has to be sent by 8 p.m.
By what?
8
8
p.m.
PM,
So
okay.
if you're using the unilateral, you have to send it by 8 p.m. So it's not that waiting until midnight to send that on the last minute.
Okay.
And I think from what I've heard in the forms committee, that's kind of like a test run with using a time frame that's different than midnight. My hope is that if they do start using a time frame other than midnight, they stick with 8 p.m. so that it's not like due diligence is at 7 and amendment to.
All different
trust-
times.
Yeah.
All over the place.
Because that would just be a headache, but 8 p.m. on your extension, which I love because we sometimes don't have lender packages
Me
until
too.
midnight. And then, people just start like, we stopped to close it because we didn't, it was there. So, especially California lenders. 7 o'clock your time, but that's.
Yeah. Hey, but that has saved me a couple times.
Yeah.
So,
Oh,
yeah.
speaking of California, one thing that's good to to talk about also, and I'm sorry if I'm stealing the broker boy's thunder for Thursday. There's a new portion of the contract that says if there's a state of emergency issued for the county and the property that's, the property's in, then the contract automatically, and all dates in there, automatically extends by the number of days of the, state of emergency.
That's a good addition.
And so last week, with the snow, the governor declared the entire state of Georgia in a state of emergency. So you could be in Savannah and have a 3-day extension. And that's totally enforceable.
And it's not, I think it's right now too, it's till next Tuesday. So, the governor just issued it, yeah,
Till next Tuesday?
till next Tuesday.
You don't have to use it.
For the weather coming through.
For the cold air. Yes, the cold air.
It's automatically extended.
Hold on.
So repeat that. What are you saying you don't have to use?
Like you don't have to extend. Like it doesn't, so your closing date doesn't have to be pushed.
Okay,
But
it
the
automatically
contract
does
automatically-
for the purposes of the state of emergency, but if all parties still want to close, you can close. Okay, that makes sense.
Because it doesn't affect you where you are, but it's affecting north
Yeah,
or
that makes
south,
sense.
like
And
it's
so, like,
still on track, yeah.
If you want to establish that, you can use that general notice in the GAR forms. So say you're worried that the last minute, somebody's going to try and use that, because they could. Right now, you could sign that general notice that says all parties acknowledge the state of emergency, the closing date will still be whatever.
Is
like-
is that part of that clause? Part of that stipulation? Or it's another form?
Just the general notice form.
Okay,
Yeah.
okay.
But I mean, like, because what I'm thinking about is in California right now,
Mhm.
there are a lot of places that, I mean, they might be in a state of emergency forever, and you want to still nail down your closing date.
If you were in a situation where you wanted to extend based on the state of emergency, would it be best practice to use the general notice form that?
You don't have to, but it's absolutely best practice. And especially if there's a lender involved, they're gonna require there be a date of the closing.
So I don't know if you were saying this, I want to clarify. In the forms committee, when you guys are meeting, has there been conversation around making everything kind of a static time of day where things have to be done? For example, everything by 8 PM. You know,
There has been talk on not everything, but on things like due diligence, things like notices that, like 8 PM on.
I would love to see that because, yeah, you're right. At 10 o'clock, I'm not gonna see somebody sending that to me.
The amendment to address concerns when you're sitting there waiting for it till midnight.
Yeah.
With your 10-6.
Yes.
But yeah, this is kind of like a trial run. They wanted to see how everybody liked having a time.
I do too.
A question that came recently because of what's going on out in California and the Helene we had a few months ago with North Carolina and stuff. So contracts on homes that now no longer exist.
Yeah.
So there was some confusion on, I know it's by state, but it's confusion on what that would look like hypothetically.
Yes. So our GAR forms extend until the seller has time to rebuild, essentially. Or you can terminate and the buyer gets their earnest money back. But it's worded more like as a loss. So like say a roof is damaged, it extends long enough to, have the repairs completed.
Had a tree fall on a house the day before closing one time and we had to go through all that.
All that. But you were saying something that made me think of something else. I need like to keep notes while you guys are talking. California fires. Oh, insurance. That's another big change. David and Henry are gonna be like, why did you tell them everything? But there's a new, in the financing forms now, for condos, up until the day of closing, it's all the way to closing, if the lender does not approve the master policy for the condominium, then the buyers can get out and get their earnest money back. And that is really
Wow.
big because
That's really big.
those policies change all the time. So like, I own a condo in Grant Park, and they had a flood, and then after the flood, we had to change the deductible for a couple of years in order to like get back to, you know what I mean? But a lot of people have FHA loans, and that wasn't gonna meet their FHA requirement. So it's a big deal. So yeah, if the lender doesn't approve the master policy, then they can get out of the contract
I'm
all the way.
surprised that hasn't always been. What did they have
Well, different lenders have different
to? Right, no
requirements.
doubt, but I mean, if they didn't approve it, what would they have to do? Just get another policy?
Well, you
or
can't.
supplemental policy?
The buyer just lose their earnest money.
Oh, wow.
Wow, yeah, that's a good change.
That is.
That's not fair to the buyer.
No, it's not. That's why we're happy that.
Yeah,
This-
that's,
That was a good
When she
That's a
told
good
us that, I think you told us that last year, and we were both like, yes.
Well, if you guys have questions after
Good
next
stuff.
week, let me know. 'Cause I know they're gonna fly through like we do when we do the contracts forms, class, but. Thank you guys. And I have, chicken salad chick when y'all are done. Just so you know, there's one tray of Classic Carol, one tray of Fancy Nancy, my two favorites.
Yeah. The best names ever.
I know. One of them is pimento cheese and
Oh, my goodness, all my
Birdie
favorites.
Friends.
Birdie Fran.
Yes.
Done. All right, give her a round of applause. Settle on and go have Fancy Nancy and Crazy Carol. You guys probably saw, what's it called?
Classic.
Classic Carol. No, Crazy. I like Crazy Carol.
I like Birdie
You guys probably saw me where I posted last week about a safety issue that happened with some of our agents. So I guess if you guys have already figured out who those people are because of the comments, I just want to like recap on that. So what happened in a nutshell? By coincidence, the best we can tell, two of agents that are on the same team together were at a listing appointment. Simultaneously, somebody spoofed their phone numbers and called family members at the same time from what looked like their personal phones.
Wow.
A gentleman on the phone, a woman screaming in the background, demanding money, saying they were going to kill them. They could not be reached immediately. So of course, family's calling. They both had missed like 30 phone calls, text messages. Anyway, one husband, Mackenzie's husband, and they called the police. She had her locations on. The police showed up. Of course, we laughed because the listing appointment, which was a brand new client, were like the craziest appointment ever when the police show up. And she did have the nerve to look at Teresa and go, does this mean I get a discount now? And she's like, no, you do not get a discount. So that happened to another agent in a market center, one of our Atlanta partners offices last fall, to a gentleman. They called his grandmother who paid somebody $5,000. So just make sure people know where you are, turn your location on, share. I tell people, create a password for your family or something like that, just to have something so in case anything happens, because people get real creative and somebody's making a living off doing this, and which is nauseating and makes me want to poke them in the eye. Were you gonna say something?
well, I have a couple questions. One is, well, first of all, ask for proof of life. So that's one thing you can do that would stop that in its tracks.
Yep.
But you don't
Password,
know
proof of
that.
life. Mhm.
When you're in the midst of something like that, it's a panic situation. Your brain is not thinking. So try to breathe and think logically.
Well, and from an AI world, because my husband works in AI and in cybersecurity, with AI, they can now replicate people's voices. So now that's become a problem. And so having a password, like just find a system with your family, your children, anybody that you think they would call or have access to, they'd be willing to pay for you. Chalk up some money for you. Make sure you just talk about that because it is a real thing and it happens way more than we think it does. Yeah, it just happened to be at the same time with two of our own agents.
So that was my other question. Okay.
I know, yeah, lots of unknowns, but yeah.
Well,
Their system was compromised, the home network was compromised.
That's what I was thinking.
They,
Yeah,
they,
because they're on the same team, all their advertising is
and you know
together.
these people and everybody was straight up. I mean, because to me, the very first thing I thought about, and I don't want to cast any disparaging remarks about these people, but it's just odd to me that it happened at these people's house to the people who were there at the same time.
Oh, well, we did talk
So
about
I
that.
started
I'm like,
going,
do you think the
okay,
client that
did
you were
they
visiting
all do
has
that?
something to do with it?
Yeah.
Yeah. And
But
so,
that makes more sense. What Justin just says makes more sense.
Yes.
yeah.
yeah,
Their
yeah,
system was hacked.
it's just
Yeah,
because,
someone was in the IT mind was explaining to me how it happened. So now my whole family, I called every single person, like 20 people, we all have
yeah.
a word.
Locations.
Well, and location and a word, like
I don't have
a clue, they ask a question. or something.
But how do you get that word if this
They're
person
unspoken.
says they have their phone in their They're saying that,
Yeah.
The way my family does it, our word is a person, and they say, hey, have you called so-and-so? Because they're the ones with the money, they're the ones that can help you or whatever. And if the person goes, oh yeah, we called that person's dead, they didn't call that person. I mean, just clues, you know.
oh, I see what you're saying. So
Yeah.
you're asking the scumbags. Okay.
We need one for the office. We used to have one in our office that if somebody felt uncomfortable, they called the front desk and said, hey, will you go get that red folder off my desk?
That's ours.
Yeah.
We can do
So
that.
we need to know that too.
Yeah, don't take any of this for granted. I mean,
No.
No, it's, I mean, it's a real thing out there. It just happened, yeah, that, I mean, I know it happens to other agents around us. It just happened at the same time with two people in our office last week, and it was, crazy.
But it's eye-opening for us to
Yeah.
pay attention.
Yeah, absolutely. We are gonna do a safety class, and Julie was like, we'll have to add that onto the conversation. So, I mean, again, just be aware of your surroundings, know where you're going.
Be aware of it.
Yeah, let somebody needs to know where you are and that sort of thing. Yeah, so just crazy stuff. So
Yeah.
anyway, just want to share, because I know I'd gotten some text messages, oh my gosh, are they okay? And I talked to them after they left, in the car, and it was just, you know, the police officer also said it's not uncommon. This happens all the time. They get calls for this all the time. And it's sad because one of them did have a son that sent money and called out.
You know, this is a little
Or
dangerous
Calvin.
because if they called Joy and said they were going to kill Maria, who is somebody that works with us, she would pay them. If they called and said me, she might not. But she would definitely take care of her.
You pay for it. I know.
It's coming, baby.
Anyway, all right, you guys, thank you, Tiffany, again. That was awesome. I look forward, and we'll get the GSCCA. Yeah, all that, on the calendar. I think for some reason we have 5 Tuesdays in March. I'll look and see. I don't know. We'll get with Abby.
And I don't know if I can finish that thought. If there's something else like this or like the GSCCA that you guys want me to do an education portion on, let me know. Because a lot of times, like, I don't need the 3 hour, like, I'm just a little.
We can do a separate class and not team meeting. So if you guys want it sooner than that, because it is a really great class for those that have done it before. Everybody's like, can we do it before that?
Yeah.
Okay. We'll work on getting a class that's not team meeting to get that done. Anyway, so thank you again for today. We appreciate you, and for lunch. You guys go enjoy lunch and come back in at 12:30 if you're hanging out with me. Have an amazing day.
How's it going?
But I've got the contract.
Yes. Yeah, just make sure you don't tell you.